the PC Act and public servant. For that limited class, suppose the magistrate says, he will not say it generally, he will only say it under your lordship's orders. Otherwise, High Court has to lay down the law. That, look, I am issuing a direction, I'm initiating this investigation, but where 17A is required, it will proceed further only after 17A is given or not given.
So now magistrate refers under 156(3).
But then comes
The
17A.
jurisdictional police or the locaयुct at whom it is referred, he may have to wait for 2 months, 3 months for approval and then begin.
That is one way of looking at it.
And then begin. Is it not that if the approval is already there and a private complaint is preferred, reference be made prior to approval, is not a better circumstance?
Then your lordship is bypass the police
No,
officers to
we are only permitting police officer only to investigate. Nobody else is investigating. After reference, only the jurisdictional police or the locaयुct will investigate. But he will investigate only after the approval is there under 17.
I understand. There's a slight issue there. Initiation is not by the police officer in your lordship's formulation.
Yes.
Initiation is by the police officer under the magistrate rule. That's the only difference. If your lordship finds that the initiation power is preserved in my model, I mean, in case it's just loud thinking about it because there's nothing so clear here. In case the initiation power, which is clearly borne out by the language of 17A, I have no doubt that 17A language bears that out.
No
also.
problem. Yes.
It is not, I mean, your lordship can interpret differently, but it does not rule it out. If that power is borne out, then it is possible to harmonize that initiation power under 17A with the private complaint and public servant character through 156(3). It will require some obvious harmonization, but that's a possible view. Anyway, I leave that. I come to 38. Section, this is only an alternative argument in the sense that it's not, it's not dispositive either way of any of our cases. 17A places a public servant on a different footing and grants to such public extraordinary layer of protection. This extraordinary layer is set by our lordships, not by me, not by. The protection, the pre-investigation may not be as stringent as stage of sanction. I've already said.
That is by the coordinate bench.
Yeah, I mean,
Yes,
by the
yes.
court, not a submission.
Yes.
Then 26.2 is neither as weak as Lalita nor as high as sanction.
Yes, that's fine.
And 26.3, not be necessary to have incriminating material to show conclusively, but it's still necessary for credible information. Then while I'm trying to harmonize to the extent I can, while a microscopic examination or meticulous consideration may not be needed, cryptic orders will nevertheless fail to meet the requisite test. In this case, at para 51, the court concluded a clear opinion had been formed by the investigating officer that he suspected the commission of an offence. Subsequently, on considering the material, the state government came to the same view. In the present case, certain important factors must be borne out. I'm applying it here. There is no view at all found by the IO. Now, this is what I want. This is my problem. There should be, otherwise, the lordship is opening the floodgates. And my word friendly governor was not intended as a mark of insult. I'm talking of a constitutional lacuna. If this 27.1 is accepted by your lordships against me, it's my submission, but if it is accepted against me, then your lordship is allowing this friendly governor or a opposite political color state government. And all these concepts of governor above politics and neutrality is now gone. Let's not live in fictions. We have governors, we have got governors who are resigning from governorship and fighting elections.
No, now to seek.
There is no such thing.
Correct. No, now if your submission is that the investigating officer only should seek sanction, approval from the hands of the competent authority, who is the investigating officer here to seek approval? There is no investigation now? Not yet commenced?
No, that he will
Not yet commenced?
That's a procedural matter. If somebody goes with a complaint,
that's what. Somebody goes with the complaint. There is no investigating officer to form an opinion and seek approval. Who will seek approval?
Complaint. Now, let me answer, my lords. First of all, your lordship will decide it in a true case. Your lordship will not be asked, as they are doing, to decide a hypothetical.
No, I am only
on the inquiry. No, what I'm doing, lordship will answer. So, there's a very clear answer to lordship. The dates in this case give the answer. This man files on 18th July. And the governor.
No, 18th July he registers a complaint.
Then 25th additional.
No, that is not taken note of, because I see the order. For want of approval, he does not proceed further.
Then second is 23rd 5th of July, he files a further information to supplement the initial.
Yes.
Then, Malas, 26th, he goes directly to governor in less than 7 days, 6 days. Now, the query my lord is putting in a case where there is no action. Malas, maybe a writ will lie to create an action. You can't say, I go today, give him 3 days and I go to the governor and bypass. 17 days can be bypassed because that's the way to do it.
That will.
But therefore, the escape route to your lordship's very valid question would be that if I try to defy and don't ever give anything, I have no inquiry officer, I have no policeman, I have nobody appointed. Well, the lordship's writ court will settle in 2 minutes. But whereas here, these dates are important because you are actually bypassing the system of 17A. 3 dates. 18th, he lodged a complaint with the Lokayukt police. 25th, he filed a supplementary information. 26th, he went to the governor. Where will the poor police officer will not function so fast? Even if they have to function. Yes. If I am deliberately not functioning, if I am a police officer,
No.
if I am the state,
First,
etc.
154.1 was 3 days before they going to the governor or registering the private complaint? No. When was the first complaint registered?
It is 18th.
18 June.
No, July.
18 July. First complaint.
Yes. 1 minute. 18th July is the first complaint by Mr. Abraham. Yes.
All right.
And he never approached the court saying that Mr. Policeman, you are sleeping. Mr. State Government, you are doing nothing. Please give a mandamus. Maharaj, if this is so, what prevents your lordship from having hundreds of people coming in saying, 17 day be damned, I am going straight to the governor? That's a point to be considered, Maharaj. Your lordship will
And
then
when
have...
did you go to the next higher authority? 12/8. Huh? 5/7, sir. 5/8. And before that, you had already sought.
He closed the doors. Actually, Maharaj, if your lordship investigates a very important question more, he then has power to go to the court. Not to your lordship, writ court. He can go under 154(3) to the SP.
No, that's what I'm asking. 154, 1 jurisdictional police, no action. 154(3) SP, no action. 200 magistrate.
No, I am going further. Writ court will give it for the asking.
And that also, a mandamus to register the complaint.
But you do nothing. You come on 18th, you go home on the 26th and say, look, I am bypassed. Thereafter, nobody is going to touch it. You go to the highest officer in the state.
All right, yes.
So these harm. Now, Manas, just look at the reverse for a minute. Just look at the reverse. This is all right. You don't have an inquiry officer. You did this. Look at the reverse. Is your lordship not being asked to accept a gigantic principle, subversive of the discipline of law, that Manas, this 17A, what is left in it, if everybody is going to the governor first? That's my reverse question.
Everybody, why will they go to the governor? Governor is the competent authority only to a few, not to everybody.
No, for any case, Manas, it is not at nobody's case that 17A is not required.
17 is required. Yes.
Now the question is that in every public servant case,
To the competent authority.
no, governor oblique competent authority, obviously, governor.
Yes.
Point is, where does the role of the police officer then remain?
After the registration of the crime.
So that's the Malas, that's the
That's
debate.
where we'll
That's
have
the
to
debate.
answer.
That's
We'll
the
have-
debate.
yes.
That's the debate. Then Malas, 27.1. In this case, directly approached, 27.2. The governor not concurred, took a different view and passed a cryptic order. Then Malas, come to page 40. This Malas I have covered now.
Yes.
Police officer is fully covered
Yes.
in the debate which
No,
lordship
this
just-
argument is over now. Yes.
And then Malas, your lordship's judgment is also cited.
Yes.
Now Malas, para 29 Malas is really a para about this act. It's a point I'm keeping alive. I'm not Malas.
Yes.
It's a point I've fully said there. Not by any remote stretch shown to be part of the discharge of my official duties. That's the
That is,
that's
the-
the-
now we have come to the crux.
So therefore, Malas, Section 17 grants protection from decisions taken or recommendations made in the discharge of their official duties. All relevant timelines and record. Now, Malas, this is not by itself the crux. It is the crux because in this case, you have shown me nothing as to how I have been involved in the discharge, where this is. That is why it's a crux. That is important to remember.
Yes.
My lord has rightly used the word crux because you have to show that I as a minister, I as a public servant, I as the chairman of a department, I as the file signer, I as the file mover, I as the recommendee, I as the statutory compulsory persona designata, something, nothing. But your discharge of official duties is because you are a public servant. So the discharge is as big as the universe, the entire universe. Now let's kindly see. Come to 29.2. The official capacity of the petitioner at various junctures enabled him to assist in fabricating record. Now, well, is this possible? Just kindly see this. This is being told to your lordships, brothers. In pleadings, is this the way to get sanctioned? And of course, none of this is dealt with. I would have liked the governor to say, I grant sanction of 1 and 2, but I call this bunkum. I reject it. He can still grant against me. See this, brothers. Various junctures assist in fabricating records. Your lordship will not work on adjectives like this. Next, recommendation or decision is made by a public servant not directly or reasonably connected with the official. He is not entitled to protection. Third, it is not the official duty to facilitate the fabrication of fake record. Well, some comma, full stop, some sign. Some collusion, some meeting in a smoke-filled, dark-filled room, doing something, well, your lordship doesn't. And this is very easy to destabilize. Anybody will take a pot shot. The petitioner cannot seek or obtain shelter under the aforesaid statutory provision as the offences alleged are not in the. This is, I'm reading his reply.
Yes.
Consequently, contends the prior approval does not apply at all. Then take your chance. Take your chance. You are the one who went to the governor. You are the one who's got all this thing going. And now you are pleading this also. And you are pleading this on one of those amazing facts of fabrication of records. Not a word, not a single comma, full stop, remotely. Then, page 44. It is pertinent to note that since the allegation against the named accused are not in relation to any action taken or recommendation made or other name, there is no requirement of prior permission or approval. Well, this is amazing. It's extraordinary. There is no answer to say that if this is so, Mr. Singh, you can be prosecuted without sanction. It is for him to take his chance, not for me. I'm only coming against what he did. I have started nothing myself. This categorical statement is not a concession. Mark 29.4 is my conclusion. And if this is true, then it's also apart from anything else, a wastage of public money and public time. If this is so, in addition, I don't know whether there's an offense of public wastage of public time. There's no offense like that. But this categorical statement is not a concession granted by the respondent, but an admission that the fundamental requirements of 17A with regard to recommendation made or decisions taken is not made out in the present case. Therefore, expatiate the impugned order. In that case, the sanction goes on this ground. 17A explicit, and I'm sorry to repeat, this para 29.2 is verbatim reproduction of his pleadings.
Yes.
No note, nothing, pleadings. So your lordship is obliged to rely upon it. I am obliged to rely upon it. The court is obliged to rely upon it. It's a pain of perjury. It's on pain of perjury. Section 17A explicitly grants protection concerning inquiries that are to be conducted solely by a police officer. The clear implication or necessary corollary is that only a police officer has the authority to seek prior approval to lift the bar. This process, much like registering an FIR under 154, 156 or 173, requires the police officer to exercise independent application of mind. This application of mind leading to a further action is the sole and exclusive jurisdiction of the police officer, and no one else can replace him. Criminal jurisprudence is deliberately limited to the involvement of private parties, ensuring minimal interference of complainant in order to protect the accused's right to a fair prosecution. It is only through recent judgments by the court that the complainants have been given a limited role. This is important, Malas. Complainants have no role except to the extent your lordship permits them in ABCD cases. This limited role is designed to uphold the integrity of the criminal. Why do your lordship not give this, Malas? Because you just can't say that you can kickstart the whole thing in motion. Allowing private individuals, 45, to move the competent authority for prior approval would create an untenable situation where the police officer's authority to apply his mind and determine whether a case merits such approval would be undermined. This is, Malas, the core larger legal question lordship should, Malas. In this case, these dates I have done, but 29.6 I have done, Malas.
Yes.
18th, 25th, and Malas, 18th, 25th, and 26th. These are the 3 dates in 29.6. Then, Malas, the SOP.
When was the approvals, before the private complaint, when was the private complaint registered?
13.8 is the private complaint.
Private complaint.
13th of August.
Right. 18.7. No, 18.7 is the first complaint.
The first complaint. 25.7 is the supplementary.
18.7 first complaint.
25.7 supplementary information.
Yes.
26.7 approaches the governor directly. Can you note one moment? Same day he issues show cause. 26.7.
That is argued. Yes.
And then, well, it goes
No,
on.
that is
13.8, 13.8 is the
That is
register.
because Lalit Kumari says when a cognizable offense is brought before the court,
Well, it's,
brought before the police, crime should be registered with, everything should be over in 1 week and crime should be registered. If it's not registered in 1 week, next rung. There, if it is not registered in 1 week, next rung, that is 200 before the magistrate.
well, then what?
That's what, no, that is
My lord
the
is absolutely
purport of
right.
Lalit Kumari.
My lord is absolutely right. What happened to Lalit Kumari when Sashikala Jolie was pending for 24 years, or 24 months?
That is approval, not
something.
Lalit Kumari.
No, but I mean, it's the same.
No,
thing.
that parity we'll see what has happened later.
No,
Because
that's
that is something that has happened now during the pendency of this petition.
yes. No, that is the judgment has come. I mean, the order has
The
come.
order has come now. It was pending 21.
Pending,
Yes.
pending. Then, Wallace,
I'm surprised that is approval or sanction is not
the
even
lordship said so.
clear.
We checked up. We were also
Yes,
surprised.
it is approval
17,
only. Yes.
Now, Wallace, last, I'm just ending, Wallace. I want to just cover some facts and then I'll
Yes.
try and end. Lordship, give me a few extra minutes, Wallace. I want to.
No,
finish.
take your time.
Wallace, 218 is page 46. I say it is virtually.
118 stage, I think, has not
virtually
yet come.
conceded. No, just read this one para only. It is virtually conceded. The Honorable Governor has, apart from granting prior approval, also proceeded to grant sanction. Your Lordship is right, but that's not what the Governor thinks. The Governor says, I am granting sanction. It's written there, Your Lordship has seen that. During the course of the submission.
218 is what is 197 under the CRPC.
Correct, 190. During the
So,
course of submissions, the learned senior counsel of R2 made a categorical statement that the impugned order is not a sanction order of 218 and must be read only as an order of prior approval. Your Lordship will record
so
this
you
because
need
that
not
takes,
you need not labor on that.
provided it is recorded. What happens is ambush points are taken. Either
No, no.
side appeals and we say,
Yes.
no, this is not decided by the judge.
No,
But why will the judge decide this? You have conceded it.
No, that is in the written submission also.
Yes, also.
Yes.
Therefore, Your Lordship, just take that note. I am not arguing for that reason only.
Yes.
Otherwise, I am demonstrating completely that this is wrong. But anyway, he's saying that it is to be treated, this itself is non-application of mine. To start treating 218s or 197s as 17A is itself non-application of.
No,
But
it's
leave that aside.
they operate in a
Leave that
different
aside. Now, Wallace,
because 197 is after investigation.
yes. Now, Wallace, no, he's saying treat it now as a 17A order, prior approval order. That's all.
Yes.
Now, Wallace, page 47 is very important. Well, it's 3 or 2 very serious errors of law were made and then the facts. Natural justice was brushed aside on the simple point. Notice was given to me and so what, I didn't send you the other 2 complaints. I was not required to give notice at all. That's the very, very far-reaching. So first argument, I gave you notice, but I was not required to give you notice. But since I'm not required to give you notice, I'm not required to send you the other 2 complaints. So my own definition of natural justice applies. And third, so what does it matter, Mr. Singhvi? There is no prejudice to you. Let's get on with the matter. All these 3 things are answered by the Supreme Court evocatively, and my learned friends have completely misrepresented the law on this point. The law is totally different. Just come on prejudice for us first. Dharampal, page 48. From the above discussion, it becomes clear the opportunity to provide hearing before making any decision was considered to be a basic requirement in the court proceeding. Later on, this is all very common, so we ignore it. The more common, the more important is to underline it. Later on, this principle applied to other quasi-judicial authorities, even in administrative, before taking a decision, hearing is necessary. Boldface, Krepak, etc. Now just see what he says, Wallace. So far, so good. However, an important question posed by Sorabji is as to whether it is open to the authority, which is to take a decision, to dispense with the requirement of principle of natural justice on the ground that affording an opportunity will not make any difference.
No, that's not.
To put it differently, can the administrative authority...
No, it can't be said. Or even if I give you notice, what will you say? That cannot be the reason.
That's I was not required to give you. Even if I gave you, I'd have the same result. No prejudice would happen. These are the angles of the same argument.
But here, he only extracts one paragraph in the order saying that there are 2 other complaints. No contents of that complaint is noticed.
That's my grievance. That's my grievance. Because he has already sent me notice. So now I'm dealing with 3 points. One, if you elect to send me notice, you are stopped from arguing that no notice is required. That's proposition 1. You're in administrative law.
Yes.
If you elect, I did not elect, you elected. You elected to send me, then you cannot say that now notice is not necessary. Second, if you elect to send me and do not send anything else, then you cannot take the plea that even if I had heard you, nothing else would have happened. They are the two main propositions.
All right.
Now, let's just come to 31.3.1 at page 49 bottom.
Yes.
49 bottom. The request for prior approval was received by the governor on the same, and third, I'm very sorry, third is the most important. He gave a detailed half-day hearing to the complainant. It can't be brushed aside by saying criminal law. I can hear whom I like. He heard the criminal law complainant. He gave me notice. Then he did not give me the notice for the other two and then said no prejudice. That's the fourth. Let's put them all together and whatever the conclusion is. The request for prior approval received by the governor on the same day a detailed hearing is granted to the person seeking. Same day, the governor further finds a prima facie view on this meeting alone and proceeds to issue show cause. Such view was formed despite the fact that documentation was mostly in Kannada. The detailed set of the governor is obviously not Kannada. So very detailed. 200 pages. I have seen, my learned friend has seen is all Kannada. Obviously, he didn't learn Kannada overnight. Prima facie case. No, these are important. If you are doing this application of mind,
Yes.
what if mind can't apply in a language you don't understand? What application of mind in a language you don't understand? The detailed set of documents provided by the third is in Kannada, application by fourth is in Kannada, fifth respondent is not even on file. The Honorable Governor, as can be seen from the response to the RTI, admits that he needed an English translation. He writes the file to proceed with the other application for prior approval.
Aid and advice of other officers.
Yes, for the others. But in the present case, Kannada seems to be the chosen language. This is in the other cases. Here, on the same day, on 26th July, he proceeds.
Yes.
In the present case, English translations were done by the governor's office is not borne out from the records. Whereas in the other cases, investigating agencies are directed to file translations. There's an order noting. Now, this is the direct proof. Well, this matter, this particular order must be set aside. Whatever order he has to pass, etc., is a different matter. The Honorable Governor, on the basis of a petition accompanied by more than 100 pages in Kannada, come to the conclusion that the allegation of serious nature and prima facie need action. Also notices that complaint is filed to the Lokaयुkt police. It is rather surprising and ironical that the Honorable Governor, unable to read and decipher Kannada, is also able to digest documents of hundreds of pages, etc., etc., and issues notice immediately. There is undue and inexplicable haste. This is not a facetious thing. It all adds up in the overall. It's not just a light game that I'm saying he doesn't know Kannada. That's not the point. He's not expected to know Kannada. I'm not suggesting a lordship. In fact, in the old days, there used to be a bar that you're not, even today is a bar. You can't be from the same state if you're a governor. The application for prior approval.
It's all right. How can you interfere? Yes, I am aware of that.
The application for prior approval sanction is received by the Honorable Governor. Addendum is on 26th. Addendum is also received same day. Let us kindly see page 51. Opportunity of detailed hearing of 3 hours is provided. And by 10:30 on the same day in the night, 10:30 p.m., a show causes notice issued. A process in such a manner by one of the highest constitutional authority against another highest constitutional functionary is unheard of. I'm saying this with a sense of response. Such application, the Raj Bhavan would on the same day reach the governor, and then hearing to a private party takes place on the same day, a show cause. This is all Article 14, etc., etc. And your lordship will see the totality of the earlier arguments also. Then, Malats, 31.3.4.1 is page 52. Sashikala Jole, all the dates are given to your lordships at one place at page 52. Murugesh Nirani is the other case.
That is also pending.
Returned on 28/8. All is happening after this case has started. He's either returning or rejecting. Approval is only my case. Well, now you have to explain the delay. Well, it happens even in the judiciary. Sometimes after 2 years, the matter is put again for clarification. So here, after 2 years, in Nirani's case, he sends it for clarification on 28th of August. Then, same thing about H.D. Kumaraswamy, return to the requesting authority. Then, it is very clear the dates are all after the hearing of this matter has started or after this matter has become a dispute. Not hearing started, but dispute. Then, application of 13th of May submitted for sanction was returned by the governor in June 2024. On 21/8, investigation replied. On 28/8, the application was returned for English translation. Well, by the way, each of these, that is, page 52, all the cases except Shashikala, page 53, all the cases are returned after they come back from the clarification, further returned for translation. I hope I'm clear. Take, for example, 53. My case, the same day, the night, same thing. Now, let us see this ground. This is very, very important, 53. In Shashikala, he does exactly what I've been laboring the whole day today. He did not do in my case. That is quoted. It is quoted once. He has given, I'm not saying it's right. I'm not saying who will challenge, not challenge, what your lordship will decide. But is it anything your lordship found? Just glance at it. Any word similar in my case? Please. In the chief secretary in his report says on 23rd of March, no proposal for grant of any tender. In such circumstance, the question of asking for a bribe does not arise. This is what I wanted, Malas. This is the meaning. Your lordship is asking me what the review judicial. This is judicial review. We don't need.
Wait, sir. I'll get back to you. Wait. Yes.
In order to attract the provision of 730, there must be a receipt for the bribe amount. The mere statement one was paid 25 lakhs paid, whether he received the amount is not clearly disclosed. For sanction on inquiry necessary to prove the demand of illegal gratification. So Malas, he's doing the ingredients of POCA. He's writing. And then Malas, he says, hence I find now.
20.
Then Malas, para 20 is read, it's already read. Then Malas, 55, I will skip till 59 because I want to take a lordship's 10 minutes on that dates. 55 to 59 are largely dates, Malas. Your lordship may just give me and then I'll just come back to it because the matter ends at 62, but just come to 63. Just come to 63.
List
Now,
of dates.
Yeah, just note on the side.
Yes.
All these documents are in the writ or filed by them. Number two, I have not gone into it. My learned friends have gone into it meticulously in the arguments. Half the argument, 3/4 of the argument, Mr. Maninder Singh was on these facts. 3/4 and others. But I want to now show the true facts. And what I've done in the table is document 1, document 2 I put on the left side. What she's got? 63.
Yes, yes.
I made one compilation of all. They're already there in the writ or elsewhere. There are 4 new documents. One is Shashikala Jole, which is not a new document, subsequent development. One is the plan, which is all are mentioned. Apart from Jole, each and every one is mentioned both in my petition and in the cabinet sanction or denial of sanction.
All right.
All mentioned. Now just see the startling consequences very quickly. Malas, 92, your lordship has a notification. And Malas, the old fellow, the earlier owner is Malas Devaraju. In item 4. When I say 4, I mean document 4.
So, Devaraj is the owner?
Then owner.
Was not there a relinquishment in favor of one Cheluraya or something? Mailaraya. How did Devaraj become the owner?
No. That is much.
1935.
Subsequent to that, a release deed in favor of Devaraju.
Where is the release deed in
Yes,
favor
yes.
of Devaraj?
Give me the page. Is it on record? Where is the and the averment in the writ? And the averment in the writ.
No, since you are replying on facts.
No, it's very
Should
important.
be clear.
Very important. Very important.
It's 10th of April, 1993.
Yes, Rangnath.
10/4/93.
ನೀವು ಹಾಕಿರೋದ್ರಲ್ಲಿ there is one relinquishment deed in favor of one Mailaraya or something. Yes.
Now, 10/4.
It was 1935.
No, let us see. The date of the writ. There one thing say one thing.
Milari was 1935 from the same family.
What the date?
10/4/93.
10/4/93 is Malas in the documents file. Give the file to my lord. Page 11.
We gave it in the morning.
Page 11.
11 to
It is release the land in favor of Devaraj, is it?
Yes.
Yeah. This is, we are talking of 93.
Huh. Which is that I have not seen this document at all.
It is.
Yes,
Right.
Rangnath, you have not produced this? No, which is this 10/4/93 document?
No, this is produced now, Malas. Produced.
Now it's not a part of the record. No, nim record allu hakilwa adu?
It is recorded in the writ. It is recorded in the cabinet thing, but document is this. Cabinet,
Where is that document?
this one, page
It
11.
is given in the morning.
That bunch we given once.
In the morning. we-
All of it is in the writ or the cabinet decision. This bunch. Kindly give the bunch. No?
All right.
No, morning. Just show the bunch.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾ.
This document mentions in the writ.
It is not in the.
It is mentioned in both Malas, my reply to the governor and in the cabinet decision.
Yes.
Now Malas, kindly come to, I obviously can't read it.
No, no, that
And
document number 3,
4, I think.
4 is it?
4. 4?
No, in
Three,
this
three,
you
three.
say document number 3, 10/4/1993.
Document 3.
ಭೌತಿಕಾತ.
Well, just for fun, we have made serial number 4. Foolish, why to make
It's all right. ಭೌತಿಕಾತ ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ? ಲಿಂಗ ಇಸ್ ನೋ ಮೋರ್ ನಿಜ. 3 ಮಕ್ಕಳು. ಭೌತಿಕಾತ ಆದ್ರೆ ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
memo?
Surviving 3 brothers.
Let's see. Yes.
Right,
All
Malas?
right, yes.
Now, kindly go ahead. Then Malas, this Devaraju makes an application in document number 4 for Malas deletion.
Yes.
Then Malas, a resolution is passed in, well, look at this person who is trying to grab all this and is so corrupt. We're talking of 93, 97. That itself, Malas, and a person comes today, I'll read that para about the antecedents of those who have come now. Keep that para ready. Keep it out. Document 5 passes a resolution that they can be excluded in 97. Then Malas, notification is issued. Now the Commissioner Muda recommends for release.
Yes.
General award is passed in document 8. Denotification is again recommended to 9. It was made to sound like a huge conspiracy that there is no denotification at all. These are all Malas.
No, denotification is there.
It is wrong. This is a government process going on. It is not something which I am the minister in charge or is done for me or not for others. Then Malas 10. Denotification is issued under 48. The Rosh was specifically told, where is 48? This is no 48. This is all false 48. I was there, Malas. It was 48 was just brushed aside as some kind of thing. What is this document, Malas? Item 10, page 47 to 51 in the writ. Then Malas, approved layout plan is important. This is mentioned again in my and Malas the cabinet, but I produced it at page 52. How do you approve a plan, Malas, by saying denotified? Can a lordship have an approved plan without of denotification without it actually happening? Somebody will go for forgery, Malas. And forgery would have happened, Malas, in 98. We are in 2024. Then Malas, very irresponsible and extremely rhetorical and hot-blooded accusations were made, making the whole thing look like a scam for 23 years. Ignoring all this, and people who knew so much to say also had all these documents. Those who argue with all this vehemence are deemed to have all these documents. You can't argue, so I did not know. If you did not know, you jolly well be responsible and don't raise it in so irresponsible a manner at such a high pitch. Then Malas 12. Notification does not show the lands in question. Now this is because it's denotified. This is the reverse thing. I'm showing an omission in item 12. An omission. Now you can say that all the documents for 25 years have been forged. Thankfully, you have not said so yet.
No, that's not.
You have
there.
not thankfully till now said so. Then Malas, personal award is passed in 13. Now it is possible, Malas, that despite this, I'm such a superhuman human being. But this is not a ground automatically without adverting to a single fact to grant a sanction. This is not the kind of case a lordship, Malas, has cases where lordship has. What has happened in Malas, the precedents have muddied the field because you have corrupt people. You have people with the same day, same this thing and all. Fast. This is not that kind of case. This is proceeding at, if at all, a inordinately slow pace in my view. In my view, a very slow pace. 13, personal award. 14, illegal allotment of sites on paper. This is a reality. Please check up. And Malas, at 61 to 71, it is found Mr. Abraham's application. Mr. Abraham's application. And they have argued and he has argued such vehemence.
No, allotment of sites is not on paper. It has actually happened. To
It is on
the
paper also.
allottees of the layout, it has actually happened. Yes, Raghunath. It has actually happened.
Paper.
Yes.
Malas, may I say,
Yes.
de facto 100%. 100% de facto. Muda is dealing with it. Nothing on the paper will happen. Nothing on the ground will happen without the paper, Malas.
True.
It can't be that in the air. This is a Muda authority. Document 14 is found, Malas, 61 to 71. Lordship may see. I put the page. What else can I do, Malas?
All right.
But
Yes.
this is not a figment of imagination. And none of this is dealt with by the governor. First time a sale deed happens is 2004. So Lordship will draw a line
Yes,
here.
first sale
from
date is
97
2004.
I mean, sale deed relevant to not him, but his brother-in-law.
It is
I mean, not him, but his brother-in-law. I'm drawing a line still. This is Malas from 92, 93, and Lordship is stopping at 2004. This is a whole decade. Then Malas, conversion of lands is applied. This is applied in 2005. And Malas, just see the next date between 16 and 17.
5 years.
Such a mad rush because he's been in politics all along, Malas. He's been either an MLA or he's been a deputy chief minister or a minister. He became a minister in the 80s. Such a mad rush, man. He must be madman, Malas, that he's taken 5 years to have a gift deed to his wife. These are Lordships reads the totality, the holistic. This is not some kind of a scam, Malas, where the man is desperately trying to grab something. He's taking 5 years from 16 to 17. Then Malas, 18. This lady, Malas, requests to allot alternate land. Now, it is not the only lady who gets it. It is not the only case of encroachment. It is not the only time it has happened. It just happened that I am the chief minister's wife also. Then, Malas, 19. Proceedings of the meeting where the application is discussed and decided as follows. This is Malas 90 to 94. This, Malas, Lordship, just note that. That thing your Lordship asked me. Just note on the side.
Yes.
My son is officially ex officio, Malas, all MLAs. I've checked.
Yes, all of them.
So
Not
that is one.
only,
No,
I'm
no,
not saying that
no,
it's
no.
only
I-
yours.
My Lord asked a neutral question. I'm giving the facts only. I'm also giving a neutral.
As an ex officio member of Muda, being
All
an
MLAs.
MLA of the constituency, you had participated in those deliberations which decided to allot alternate sites. Is
Number
the
two, no, but there's
submission.
something more interesting. Malas. The minutes of the resolution of that meeting are fascinating. They are in the relevant, the same volume, page 96. All the people, including MLAs who participated,
Yes.
contributed.
Yes.
This man did not say a word.
It's all right.
No,
Yes.
I'm just saying there's no participation.
Yes,
He's sitting,
yes.
he's attending. There's no participation in decision making. None. None.
I'm not-
And this complaint is against me.
No, the complaint is against you.
Yes.
That's all right.
And fourthly, that person, my son, is not made a accused. Now, Malas, if it is private,
Yes, all right.
right. Now, Malas, very well. Now, Malas, today, if Malas, I am to be culpable because of this one incident of 19, which is happening in 17, when Malas, this event happens, then Malas, your Lordship will see the totality also. That's the point.
No, their allegation is the beneficiary is the roof.
I understand. Malas. This is the allegation is much
The
more.
roof of the chief
This
minister.
son came now, Malas. The allegation is that this is happening from last, all the decisions, this denotification is the allegation. The encroachment is the allegation. No son, no father, nothing but it's the allegation. This is only the Malas consequential decision which is coming up now. That act has happened.
It's an
earlier.
allegation, not a conclusion. It's an allegation.
Now, Malas, my first point is, have you dealt with it anywhere in your order, Mr. Governor?
That will, yes.
Have you then shown that is there any connection with me in a manner which can be credible? Have you addressed it? There is a whole para which addresses it in the cabinet decision.
Yes.
Have you then dealt with that para and said this is wrong because of 1, 2, 3, 4?
That I will answer.
This is
Yes.
the. And then, Malas, then of course, willingness given.
What?
Now come to Malas, document number 23. No,
Can I just-
sorry, before that.
No,
no.
it's-
20 onwards, Malas,
speech again, but I
20,
think that
20
is there.
onwards is very important. Just draw second line at 20. That is 14, 11, 19. I am in the opposition. But should I put that line there? Item 20.
No, yes.
Now then, Malas, the principal government department writes to Muda to take a decision at their level. Proceedings of the meeting of Muda where it decided to give 50% of developed area as compensation. Willingness given by not me, but by Malas, 14 or 15 other people across the state, or where not across the state, in the relevant areas. Then Malas, relinquishment deed, etc., the last 4 days. Now, Malas, the last part
It's like 50,
is
50. Because
come
the
to
people
Malas,
who
the
benefit-
submissions at page 55. Come to 55, the submission, I am done, Malas. So, Malas, there has to be a proportionality for this one meeting and most of the time outside of the power. If you are going to go that far, then totality doesn't justify, you have not dealt with the administrative law aspects.
You told me to remind about R3's antecedents.
Then come to para 32 of my note, page 55.
55.
Yes. So 32 and 33 gives the same list of dates. All the way, to the end of 56. Come to 57 top, the denotification is not specific to the subject lands, extended to other lands.
No, it is, denotification is not only this land, it is something else. A denotification happens to the adjacent land. That is also there on record.
19 is what I've said, at page 57, 19
What is
examples.
this survey number denotified?
464.
462.
462 now.
462.
One person.
464.
462 or 464?
462 and 464.
460.
19 of the problem.
Now 19 other is important, at page 57.
No, all that is there.
Yes. Then, just note that these are impressions given to your lordship in the prejudice part of the argument. Therefore, I'm just very quickly clearing them. Now, 33.3.1. The notification does not, under 16.2, does not cover the lands in question, and the lands were therefore excluded. This notification is 33.3.1, of my note. No Panchnama, no inquest report, no memorandum, no sufficient documentation as required under Indore Development Authority regarding taking over of possession. Your lordship is told taking over of possession. Then, now, this para 33.5 I have put in boldface. I need a seat for a minute. Allegations questioning title are based on suppression of the crucial family settlement. Now, you are questioning my title. Inside my family, there is no dispute. It's a family settlement at para 33.5. Number is given. Register is given. There is no jhagda, but somebody else is
No,
questioning.
that's not the submission also.
Then, that other writ, is identical for this reason. That's very important, to remove that impression. Where, the matter was not proceeded with and the land was released.
Which one, sir?
Other writ was said that we have suppressed the writ number and all that.
Siddaramaiah.
Sundarama's case. Sundarama's case is only cited for the point that another case where actually acquisition was not
Oh,
continued.
that Justice Bhajantri's order.
Yes.
Yes.
It is not continued. So also in my case, acquisition is
Just
not
one
continued.
second.
Just 5 minutes more.
Just one.
So 61 is very important. 50-50 benefit given by taken by hundreds of people. It is not just me who's got it. 61, we have made a chart.
Yes, sir.
Now, that other matter, just see 61 and I'm done in 2 minutes. 61 is a list. This is important. I put a chart.
Yes. And
This
there-
Muda, look at what it did for an overall policy, Look at the number of sites, 50-50 ratio. This can't be, any kind of an individual case, Then sanctioned without land acquisition, 570. First one is without compensation, 358. Without acquisition, 570.
Yes.
Then prior to the date, 99. After the date of 5/1/22, 835. This is completely, to particularize it as if some kind of conspiracy by an interested party is wrong. This is an all Karnataka thing. Then, Sundarama is important because, just note one thing, 33.8.3, which is at page 61.
There is no distinction between the case.
That was what was thought to be said. There is a vital distinction. There is none. Where land acquisition is not initiated, and a case where land acquisition is initiated, but the land is later denotified. That was the example being given. We have given an analogy. We are not saying we are that case. We were saying that land acquisition was in the process, was not initiated then. Mine was the case initiated but withdrawn. So the result is the same. There is no distinction. Lastly, just note my writ, para, page 31. Page 31. This also
Of the writ petition? No, of this
31, yes, in the main writ petition.
Yes, it's main writ petition.
Main writ petition. 1, 2, 3, 5, 6.
Krishna, you said nip it in the bud.
Yes. Page,
Well, it is also important for such matters. It is not that it's a rule of law, but the sanctioning authority gets a feel of the case. It is not that everybody on Malas will come and start doing this. Frivolous, vexatious, or dubious antecedent people should never be encouraged because this is a much larger repercussion. You are protecting public servant anyway. Here you are protecting a public servant against fellows dubious people or dubious antecedents with fellows frivolous, vexatious objectives.
what's dubious?
Yeah, come, 31. 31.
No, who's dubious here?
This particular person was 631.
Page 31.
When you're reading the paragraphs,
No, you just say it's your name.
the credit, no.
Oh, antecedents of respondent number 3.
This is one example. Let me, Mr. Abraham is a crucial factor. He is a habitual litigant, well-documented history of engaging in blackmail, extortion, and the misuse of legal processes.
No, I would put it this way. Yes, it may be. A whistleblower will always face these problems.
Provided he doesn't have, a whistleblower need not have an antecedent thing. This is not
No,
this
any
25, no.
any whistleblower will always face this problem.
Correct. Will the Supreme Court impose 25 lakhs cost on a there can be whistleblowers
him?
without this?
On
Next
him?
sentence, please
All
read,
right,
Manas.
yes.
It's not
see.
a,
Yes.
he is a habitual, I have put words here, Manas, advisedly. He is habitual litigant with a well-documented history of engaging in blackmail, extortion, and misuse. His conduct has been repeatedly condemned by various courts. Supreme Court imposed a cost of 25 lakhs in SLP. 25 lakhs is not given in 2017 in even 1 or 2 cases for abusing PIL. In addition to the history of vexatious, respondent has been involved in criminal activity. But a lordship is a judge who takes a holistic view. Ultimately, judges have to take holistic view. FIR registered in 2023 for offences including, can't you have whistleblower without all this, fellas? Extortion, outraging the modesty of a woman, criminal
Outraging modesty.
intimidation under sections 384, 506. Complaint filed by Sudha, a government official, alleges that Abraham attempted to blackmail and
384 is
intimidate.
not outraging modesty of a woman.
What is the
Oh, that
section of
matter. 384 is extortion.
384 is extortion.
All right, yes.
The complaint filed by Sudha, government official, attempted to blackmail these serious
Sir,
criminal antecedents evident that
sir,
he lacks.
if we can do this, you give me 5 minutes, I'll resume. Whatever it is, I'm going to complete this today.
I have in fact finished.
Yes, sir. I'll get back in 5 minutes.
Certainly,
Yes.
certainly.
Sorry?
He's going to conclude today. If you want to argue, you can argue with me.
Yeah. You have practically covered,
No,
I just
whatever you want to
take him
say.
through.
Yeah.
I'll take him through those.
What I'm saying is. Anything else?
built up on the representation of or the application of Mr. T.J. Abraham,
Yes, Abraham.
which was filed on 26/7.
Yes,
Kindly come to page 9.
all right.
There is a reference to 3 petitions.
Yes,
Item number 3 is a petition from Siddaramaiah Krishna,
there's the fourth respondent.
dated 5/7.
Hmm.
I want to know where is that file? Why it is not placed before the court?
So it is in the original file.
No,
Not
it
there
has,
in the original file? All right, yes.
anyway, it is not given to us.
No, original file is not given, only the.
ಅಲ್ಲಲ್ಲ
author's-
ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. No, what I want to tell the court is, ಅಷ್ಟು ಪ್ರೀತಿಯಿಂದ ಅಬ್ರಹಾಂ ಕರೆದು ಕುಂಡ್ರಿಸ್ಕೊಂಡು 90 ನಿಮಿಷ ಮಾತಾಡಿದ್ದಾರೆ. ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣನ್ ಪಾಡೇನಪ್ಪ ಅಂತ. ಅವ್ರನ್ನೇನಾದ್ರು ಕರೆದಿದ್ರ, ಅವ್ರನ್ನ ಮಾತಾಡಿದ್ರ, ಐ ಥಿಂಕ್ ಮೈ ಲರ್ನೆಡ್ she will not interfere with my submission.
All right, wait.
5/7/2024. That is the first application given. What is the deliberation of His Excellency on that petition? Is a file opened at all? If so, what are the orders passed? Why notice was not issued in that first petition that was filed before? So is the case with Pradeep Kumar,
The fifth respondent.
fifth respondent. So this is one issue which needs to be addressed. Now, be that as it may, kindly come to the order that was dictated
By the governor.
by the governor.
Yes,
That is what
yes.
the
that is
note
what-
says.
Yes.
Governor doesn't say this is the order. No, notes. We have to infer that this must be the order.
Dictated.
Dictated. Now, para 27 onwards
Is the dictation.
is the supposed dictation. Kindly come to. So the first one are all in the nature of preamble. What happened? Para 30 deals with Council of Ministers and the contents of the cabinet
Yes.
advice. I'll not trouble the court with the text of it because it only extracts what the cabinet has advised. Kindly come to para 31.
Hmm.
In view of the averments made in the aforementioned petitions, seeking grant of sanction for prosecution and the materials in support of the same, the subsequent issuance of show cause notice dated 26/7/2024,
Mhm.
reply to the show cause notice by Sri Siddaramaiah, Honorable Chief Minister, legal opinion of the learned Advocate General, and the decision of the Council of Ministers dated 1/8, I am of the opinion that in exercise of my powers under Article 163(1) of the Constitution of India, considering the aforesaid materials placed before me and the facts and circumstances of the present matter, as a matter of propriety, I shall exercise my discretion. So this is where His Excellency comes to the conclusion that he will exercise his own independent.
That is because he concludes that the decision of the cabinet, decision of the Council of Ministers is irrational.
No. Previous paragraph, there is no such thing. Court,
Allah, the order.
Allah, I bow down to Allah. We can't disjoint the order from the note.
All right.
Order is a product of this. I will also demonstrate how it is a product of this very note.
Yes.
Because the order by itself does not contain any.
No, order does not contain, but the order does contain the words. I decided to exercise discretion on the score that the Council of Ministers' decision is irrational.
If I may say so, the order is a very interesting order.
No, page 44 of the petition, the order says.
ಅಲ್ಲ ಅದನ್ನ I'll deal with it. ನನ್ಗೊಂದು ಕತೆ ಜ್ಞಾಪಕ ಬರುತ್ತೆ. ಒಬ್ಬ ಭಕ್ತ ಅವನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬೇಕು ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ ಡಿಸೈಡ್ ಮಾಡ. ಈ ಡಿಸೈಡ್ಸ್ ಟು ಗೋ ಟು ಕೈಲಾಸ, ಶಿವನ ಹತ್ರ ಹೋಗ್ಬೇಕು ಅಂತ. ಆ ಹರಿಗೆ ನಾನು ಪೂಜೆ ಮಾಡಿದ್ರೆ ನಾನು ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ಬಿಡ್ತೇನೆ ಅಂತ 2 ಲೋಲಾಕ್ ಕಟ್ಕೋತಾನೆ. ಕಟ್ಕೊಂಡಾಗ ಏನಾಗುತ್ತೆ, ಹರಿಗೆ ನಾನು ಯಾವ ಕಾರಣಕ್ಕೂ ಪೂಜೆ ಮಾಡಬಾರ್ದು, ಕೈಲಾಸಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂತ. ಬಟ್ ಅವ್ನು ಎಡಗಡೆಗೆ ತಿರ್ಗಿದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ, ಬಲ್ಗಡೆಗೆ ತಿರ್ಗಿದ್ರು ಹರಿಗೆ ಜ್ಞಾಪಕ ಬರ್ತಾನೆ. ಸತ್ತಾಗ ನೇರ ವೈಕುಂಠಕ್ಕೆ ಹೋಗ್ತಾನೆ. ನನ್ನನ್ನು ಯಾಕಪ್ಪ ಕರ್ಸ್ಕೊಂಡೆ, ನಾನು ನಿನ್ ಭಕ್ತ ಅಲ್ಲ ಶಿವಭಕ್ತ ಅಂತ. ನೀನ್ ಮಾಡಿದ್ದಿದೆ ತಪ್ಪು. ನೀನ್ ಪ್ರತಿ ಸಲ ಲೋಲಾಕ್ ತಾಕ್ತಾಗ್ಲು ನನ್ ಜ್ಞಾಪಿಸ್ಕೋತಿದ್ದೆ, ಶಿವನ್ ಜ್ಞಾಪಿಸ್ಕೊಳ್ಳಿಲ್ಲ. ದಟ್ ಇಸ್ ವಾಟ್ ದಿ ಗವರ್ನರ್ ಹ್ಯಾಸ್ ಡನ್. He is obsessed with the cabinet note. All right, he rejects the cabinet advice. After that, what has he done?
So that was the material before him in reply. So he has to look into it.
That he has not done.
That
For
here in
example,
the order. yes.
Chief Minister's reply is there. I will point out that also. Not a whisper in the entire order. Not a whisper in the order sheet.
No, the defense was that Chief Minister's reply, the cabinet note are verbatim similar. So one is taken into consideration.
We can reject.
Wait, Rangnath. Yes. Adalle irli. Yes.
No, cabinet.
No, that is the
No,
argument.
cabinet advice may be refused to be looked into. That he has said so. But he can't refuse to look into my reply.
No, the argument was there verbatim similar.
That order should say so.
ಅಲ್ಲ,
Your
argument-
argument to. Our argument ಹೇಳಿದ್ದಕ್ಕೆ
Yes.
may I request the court to kindly just one paragraph I'll show. Mohinder Singh.
All that para 8, 851, 78, 851, para 8. Yes.
May I just read that? And the second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise.
Statement of objections or otherwise.
Otherwise, an order bad in the beginning may,
Will get validated.
by the time it comes to the court, on account of a challenge, get validated by additional grounds.
The orders are not like old wine getting better by the day. Yes.
Govardhan Das Banji, quote, public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer, not even by the contesting. Even if the officer gives it, it can't be accepted. Making the order of what he meant, or of what was in his mind, or what he intended to do. Public orders publicly made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Unquote. Orders are not like old wine becoming better as they grow older. So that is what, so it has to be summarily rejected, whatever arguments or justifications are given. I'll come to the order later. Now kindly see that the court says there is a reference to it. May I take the court to the impugned order, volume 1 of the petition. Alla ee kottidru.
Same. Volume 1 of the petition.
Volume 1 alli ಇದೆ.
Yes, sir.
Paragraph, page 41.
Yes.
Para 1 quotes the order.
Yes.
Para 2 quotes the two petitions given.
Para 3 show cause notice.
Para 3 show cause notice. Para 4
Committee.
council about the committee.
Yes.
Then para 5 the resolution of the
decision.
cabinet
Yes.
resolution. I have considered the decision of the cabinet dated 1/8. That is para 6. And file in relation to the issue at hand. It is noticed from the said file that Sri so and so had asked the chief secretary to convene a meeting of the cabinet and to place the show cause notice dated 26/7 and all other materials before the cabinet. Accordingly, the cabinet meeting was convened on 1/8/1918, wherein show cause notice dated 26/7 and other materials were discussed, and the aforesaid resolution dated 1/8/2024 came to be passed. I have also taken note of the fact that the said cabinet meeting was not presided over by Sri Siddaramaiah, the Chief Minister. So it only narrates what the cabinet has done. In the present case, the petitions have been filed seeking grant of sanction against Sri Siddaramaiah. The resolution dated 1/8 of the cabinet has been passed by the cabinet colleagues of Sri Siddaramaiah, who have been appointed on his advice. In view of the above, and considering the fact that the petitions have been filed seeking sanction for investigation and prosecution against Sri Siddaramaiah, Chief Minister, I have also independently examined the petitions and documents submitted in support of the same, not the representation of the same.
Yes.
Now, since the sanction is sought against Chief Minister himself, the surrounding circumstances of placing the show cause notice and the decision of the cabinet would not inspire confidence to act on such advice. So it is about cabinet advice. Para 9. Subject of binding of the advice, again it quotes the cabinet this thing, and quotes Madhya Pradesh police establishment case. That is it. Then para 10. This is where a decision is taken.
Upon perusal of the material.
Upon perusal of the petition, sir, not material.
Petition along with the material.
Along with materials in support of the allegations in the petition and subsequent reply of Siddaramaiah and advice of the state cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. It doesn't spell out what are those two versions. It is very necessary that a neutral, objective, and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of offences. Nearly 25 offences are cited. Which of those offences? For example, forgery is alleged. Is it the case that the governor is satisfied that Chief Minister has forged?
This is the first question I asked him the other day.
Yes.
Anyway, he will answer.
Yeah. So, my very respectful submission, this is not consideration of the representation. And the very interestingly, the note is important. That's why I was reading para 31 in the note. So this is all what the order says.
Order says. The governor's note is there.
Governor's note
Yes,
alle.
yes.
Para 31 alle.
Yes, yes. You can read, yes, sir.
Yes. In view of the averments made in the aforesaid petitions, seeking grant of sanction for prosecution and the materials in support of the same, subsequent issues of show cause notice dated 26, reply to the show cause notice of by Sri Siddaramaiah dated 3/8, legal opinion of the learned Advocate General, and the decision of the Council of Ministers. I am of the opinion. So considering all this, what is the opinion formed? I am of the opinion that in exercise of my powers under Article 163(1), considering the aforesaid material placed before me and the facts and circumstances of the present matter, as a matter of propriety, I shall exercise my discretion by independently examining the aforesaid material. So he now proceeds to examine. What does he examine? 31.1. It is seen from the resolution of the Council of Ministers. The conclusion has been arrived at by the Council of Ministers by non-consideration of relevant material facts. For instance, the Council of Ministers has taken into consideration that absence of possession notification or a measure taking possession was mandatory.
Yes.
However, the revenue transfer certificate as provided under Annexure A5 of the petition by T.J. Abraham clearly stated possession of the alleged land was with Muda. Further, the fact that the alleged land was developed, etc., I'll come to it later. So, Governor is satisfied, possession is with Muda. Because Abraham says so, and cabinet advice to the contrary is rejected for that reason.
So documents are there.
I am obliged.
Muda's name is there everywhere.
I'm
That is what
deeply-
is said.
I am deeply obliged for that. Kindly come to documents of Abraham.
R3 ಕೊಡಿ.
90 minutes governor has heard. I think this was the only pertinent question he should have asked. Kindly come to para 51.
Para 51.
Sorry, page 51. This is Abraham's petition. which-
Objections.
No, Abraham's application, sorry,
Complaint.
complaint, which starts at page annexure B, page 48.
Sorry.
I'm sorry. ಗಡ್ಬಿಡಿ ಆಯ್ತು.
ಇಲ್ಲ, ಇಲ್ಲಿ ಫೈಲ್ ವಿತ್. Page?
Page 48,
Yes.
annexure B.
You are referring to the complaint of TJ Abraham.
Yes, R3.
That is found in which,
This is what the learned, I mean,
no, you're
The
reading the
index-
governor's note or the
no, governor's note refers to Abraham's contention.
complaint?
Complaint,
That is page 50?
page 48, annexure B.
48 it starts, annexure B.
Ah.
Yes, sir.
Yes. Now kindly come to page 51.
Hmm. Yes.
Award declared,
Hmm.
page 51. On 30th March 1998, subsequent to the notification dated 20th August 1997,
Ah.
the preliminary award notice dated 20th August 1997,
Hmm.
the award decision notice dated 12/3,
Hmm.
and the final award notice indicating award of 3,24,000
Hmm.
was issued on 33 to Ninga, son of Javra.
Hmm.
Sir, Ninga is dead
Hmm.
28 years ago.
But the award notice refers to Ninga.
It is issued in his name.
Yes.
It is issued in name.
Hmm.
A copy of the preliminary award notice, the award decision, etc., are produced.
Hmm.
Then immediately, next sentence, he stumbles on this conclusion. Possession with Muda.
Hmm.
As a consequence of the notification, the entries for the year 98-99 in the RTC
Hmm.
indicates that the said lands were in the ownership and possession of Muda,
Hmm.
effectuated by so and so. Now the question is, when was the possession taken over by Muda? He doesn't say so. Why he doesn't say so, I will refer to it. Kindly come to annexure B1.
No, possession was taken over by Mood. No, he may say or is not said. But does the fact remain that possession was taken by Muda after the preliminary notification, final notification, award notice, then Muda is in possession. Everywhere it is said Muda is in possession.
I am obliged.
Symbolic
Kindly
or
come-
physical.
I am obliged for that also.
Yes.
Kindly come to annexure B1.
That's the annexures that were read out earlier.
Sir, this has been suppressed. I'll point out.
What has been suppressed?
The fact that possession was not taken.
Where is the document?
I'll show that. Kindly come to annexure B3.
D3,
B3,
B3.
page 105. This is the crucial document. I request the court to kindly permit me to read.
Yes,
It's a very
please.
short document.
Yes, yes. Award notice.
This is award notice
Yes,
under section 12(2)
yes,
of the Land Acquisition Act.
yes.
So everything is addressed. Ninga, as
Ninga.
court observed, it
Yes.
is Ninga Uruf Javra.
Hmm.
Property name is correctly described,
Hmm.
no problem. Kindly come to the narrative at the bottom of the page. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತಿಗೆ ಅವಾರ್ಡ್ ಆಗಿರುವ 3,24,700 ರೂಪಾಯಿ ನೀವು ಈ ಆಫೀಸಿಗೆ 15/4/98 ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಗೆ ಈ ಜಮೀನಿನ ದಾಖಲಾತಿಗಳ ಸ್ವತ್ತಿನ ಮೇಲಿನ ಕಂದಾಯ ವಗೈರೆ ಪಾವತಿ ಮಾಡಿರತಕ್ಕ ದಾಖಲಾತಿಗಳು ಹಾಗೂ ಈ ಸ್ವತ್ತಿನ ತಹಲ್ವರೆಗಿನ 13 ವರ್ಷದ ಬಾಬ್ತು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸಮೇತ ಹಾಜರಾಗಿ ಮೊಬಲಗು ಪಡೆಯತಕ್ಕದ್ದು. ಮೇಲ್ಕಂಡ ಸ್ವತ್ತು ಪ್ರಾಧಿಕಾರದ ಕೆಲಸಗಳಿಗೆ ಬೇಕಾಗಿರುವುದರಿಂದ ಅದನ್ನು ಈ ನೋಟಿಸು ತಲುಪಿದ ಡ್ಯಾಶ್ ದಿನದೊಳಗಾಗಿ ಅದು ಕೂಡಲೇ ಇರಬೇಕು. ಐ ಡೋಂಟ್ ಗೆಟ್ ದಿ ಇಟ್ ಇಸ್
ತಲುಪಿದ ಕೂಡಲೇನೆ.
ಕೂಡಲೇ ಇರಬೇಕು.
ಎಸ್.
ಕೂಡಲೇ ದಿನದೊಳಗಾಗಿ ಖುಲಾಸು ಮಾಡಿ ಇಲಾಖೆ ಮಜುಕೂರಿಗೆ ಒಪ್ಪಿಸಿಕೊಡತಕ್ಕದ್ದು.
ವೆಕೆಟ್ ಮಾಡಿ
ವೆಕೆಟ್ ಮಾಡಿ ಪೊಸೆಷನ್ ಸರೆಂಡರ್ ಮಾಡಿ ಅಂತ. ತಪ್ಪಿದಲ್ಲಿ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಕಾಯ್ದೆ 16ನೇ ಸೆಕ್ಷನ್ ಮೇಲೆ ಸ್ವತ್ತು ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲಾಗುತ್ತದೆ. ಕೈಂಡ್ಲಿ ಮಾರ್ಕೆಟ್. ಸೊ ದಿಸ್ ಈಸ್ ದಿ ನೋಟಿಸ್ ಡೈರೆಕ್ಟಿಂಗ್ ಹಿಮ್ ಟು ಸರೆಂಡರ್ ಪೊಸೆಷನ್. ಅಲ್ಲದೆ ಇತ್ತೀಚಿನ 3 ವರ್ಷಗಳ ಎಟ್ಸೆಟ್ರಾ ಅದೇನು ಬೇಡ. ಸೊ ಯು ಸರೆಂಡರ್ ಪೊಸೆಷನ್ ಇಮಿಡಿಯೇಟ್ಲಿ. When was this served and on whom it was served? It was served on one son, Mallaya. It was served on 18/4/1998. 15/4 ಬಂದು ದುಡ್ಡು ತಗೊಂಡೋಗಿ ಅಂತ ಕೊಡೋ ನೋಟಿಸು 18/4 ತಲುಪುತ್ತೆ.
4 days ಅಲ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಅದೇ ಆ ಇವೆಂಟ್ ಆಗೋದ್ಮೇಲೆ, ಆ ಡೇಟ್ ಆಗೋದ್ಮೇಲೆ ತಲುಪುತ್ತೆ.
ಹಾಗೆ.
ಸೊ ಅವ್ನು ದುಡ್ಡು ತಕೊಳ್ಳೋದ್ ಸ್ಕೋಪ್ ಇರ್ಲಿಲ್ಲ 18/4. ಸೊ ಅವನು ಅದರಲ್ಲಿ ಹೇಳ್ತಾನೆ ನಿಂಗ ಪಾವತಿ ಆಗಿರೋದ್ರಿಂದ ನಾ ತಗೊಳ್ತೇನೆ ಅಂತ. ಬಿ ದಟ್ ಆಸ್ ಇಟ್ ಮೇ, ಅದು ಬಿಫೋರ್ he was dispossessed, either he should have surrendered thereafter and there should have been a measure. Not a scrap of paper is produced by them to say that any such measure was conducted or possession was taken. Much less any details are given as to when and where, by whom possession was taken over. Now, after the award notice, immediately within a month thereafter, denotification happens. That is at page 110.
Yes.
18/5.
18/5/1998.
Yes. It is gested on 4/6. Page 110, Annexure C. ಇವತ್ತು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೂ ಇದೆ ಅದು. ಅಲ್ಲ, ಇವತ್ತು ಫ್ರೆಶ್ ಆಗಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲೂ
ಇದೆ. Those documents have. It's a compilation of all.
Anyway, ಇದು this is denotified 464 ಕನ್ನಡದಲ್ಲಿದೆ. ಕನ್ನಡ ಅಂಕಿಗಳು page 111.
The government takes a decision to denotify?
Yes.
Yes. All right, government order. Notification.
Yes, government notification. And it's a gazette notification. And it is pursuant to the deliberations of the committee, which my learned friend Dr. Singhvi has already highlighted. Now, very important to take note here is that after the denotification, no further development has taken place. Possession was either asked or pursued after the denotification. Obviously.
But layout is formed, everything is done.
ಹೇಳ್ತೇನೆ ಒಂದು ನಿಮಿಷ.
ಅಲ್ಲ, no development
Land
has
Acquisition
taken
Act.
place.
ಅಲ್ಲಲ್ಲ, ಒಂದು ಲ್ಯಾಂಡ್ ಅಕ್ವಿಷನ್ ಆಕ್ಟ್ ಒಂದು ನಿಮಿಷ ತಾವು ನೋಡಿದ್ರೆ
ಕೊಡಿ.
ಸೆಕ್ಷನ್ 48.
Yes, denotification.
Yes.
Yes.
Old Act.
48 ಓದಿ. Yes. ಇದು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ವಾ, ಅದಿರಲ್ಲ. ಅದಕ್ಕೆ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು. ಅದಕ್ಕೆ 482 ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲ್ಯಾಂಡ್
ಇಲ್ವಾ?
ಅಕ್ವಿಸಿಷನ್
ಇಲ್ದೇ ಇದ್ರೆ ನಾನು
ಇಲ್ಲ ಅಂತಾನೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಅದಕ್ಕೆ ಓದಿ ಅಂತ ಹೇಳಿದ್ದು.
on section 48,
Yes.
1. Except in the case provided for in section 36, this does not come under that. The government shall be at liberty to withdraw from the acquisition of any land. Kindly mark the next phrase, very important. That's a condition precedent, of which possession has not been taken.
Yes, and that I am aware.
Sir,
Fort-
this is
48
condition precedent. When there is a notification and I have shown that no possession was taken, how can the governor come to the conclusion there is a possession with the Buddha? How can the complainant misrepresent to the governor?
Is it not that once final notification is issued and award notices, award is passed determined, it vests with the government?
Sir, vesting is different from possession,
All right.
with great respect.
Yes.
Otherwise, why would notice be given? More importantly, kindly permit me to show that under section 16, they are entitled to take possession.
Yes.
Six-
Land Acquisition Act. ಅದೇ
Six-
ಸರ್ಗೆ ಕೊಟ್ಬಿಡಿ.
ಬಂತ 16
ಇದು ಬರಲ್ಲ. ಐದುವರೆ ಆಗೋಗಿದೆ.
16(1) ಒಂದ್ ನಿಮಿಷ ನೋಡ್ಬಿಟ್ರೆ possession has to be taken under section 16(1).
Yes, sir.
It is very well established that possession has to be taken by drawing a measure.
Yes, that is.
No such measure has
There
been,
is no measure drawn.
no measure drawn whatsoever.
Yes.
So 16(1) possession is not taken.
So the submission is, it's still vested, still the land was in possession of the legal heirs of Ninga.
It continued to be a
Continued to
private
be-
land,
Continued to be a private.
private land.
Therefore, it was not a subject.
And this was conclusively established when a 16(2) notice, 16(2) one ನಿಮಿಷ.
Yes,
16(2) notification was issued.
yes.
That notification we have placed before the court today, which is a gazette notification.
Hmm.
So if possession is taken, it will be notified in the gazette under subsection 2 of section 16.
16, yes.
Sir, ತಾವು ಇವತ್ತು page 53
ಇವತ್ತು ಕೊಟ್ಟಿರೋದ?
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಡಾಕ್ಟರ್ ಸಿಂಘ್ವಿ
ಇಲ್ಲ, yes.
document number 12, page
Yes.
53.
All right.
ಸೊ ಇದರಲ್ಲಿ ಕೆಸರೆ ಗ್ರಾಮ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಬರುತ್ತೆ. ಕೆಸರೆ ಗ್ರಾಮದ ಅಕ್ವೈರ್ಡ್ ಲ್ಯಾಂಡ್ಸ್ ಎಲ್ಲ ಎನ್ಯೂಮರೇಟೆಡ್ ಆಗುತ್ತೆ 1 to 24.
ಹ್ಮ್.
ಇದರಲ್ಲಿ 464 ಬರಲ್ಲ.
ಹ್ಮ್.
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ in seriatim the survey numbers are mentioned. Kindly come to item 34, which is 455.
ಹ್ಮ್.
455 ಆದ್ಮೇಲೆ 464 ಬರ್ಬೇಕಿತ್ತು.
ಹ್ಮ್.
466 ಕೊಟ್ಟೋಗ್ತಾರೆ.
ಹ್ಮ್.
ಯಾಕೆಂದ್ರೆ 464 ತಗೊಂಡಿಲ್ಲ.
ಹ್ಮ್.
ಅದಾದ್ಮೇಲೆ ಎಲ್ಲೂ 464 ಬಂದಿಲ್ಲ.
What is document 13?
13.
ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ಡಿಟರ್ಮಿನೇಷನ್.
ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಪೊಸೆಷನ್ ಅಲ್ಲ.
ಅಲ್ಲ, ಅವಾರ್ಡ್ ನೋಟಿಸ್
ಕೊಟ್ಟಿದ್ದಾರೆ. ಐ ಡೋಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅವಾರ್ಡ್ ನೋಟಿಸ್.
ಅಲ್ಲ, ಆಫ್ಟರ್ ಡಿನೋಟಿಫಿಕೇಶನ್ 15/2/1999.
I request the court to kindly mark one thing.
That's what, yes.
What happened was, now this notice was taken out on the basis of the common award that was made. I think common award is also produced.
ಅದೇ
before.
ಕಾಮನ್ ಅವಾರ್ಡೇ ಓದಿದ್ದೆ ಅವಾಗಲೇ. Yes.
Common award. Page 29 ಅಲ್ಲಿದೆ. Yes. Page 29 ಅಲ್ಲಿ it is dated 31/10/97.
Yes. After the final notification.
464 is specifically mentioned in line number 4.
Yes.
ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ಗಳು.
ಆಮೇಲೆ ಅದಿರಲ್ಲ.
ಸೊ ಇದಕ್ಕೆ ಅವಾರ್ಡ್ ಆಗಿದೆ, ಕಾಮನ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ, ಇದು ಜನರಲ್ ಅವಾರ್ಡ್ ಅಲ್ಲಿ ಆಗಿದೆ.
ಅದಕ್ಕೆ
ಆಗಿ
ಡೆಪಾಸಿಟ್ ಮಾಡಿ
1,52,00,000 ರೂಪಾಯಿ ಟೋಟಲ್ ಅವಾರ್ಡ್ ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ.
ಕಾಮನ್ ಅವಾರ್ಡ್
ಎಲ್ಲದಕ್ಕೂ ಸೇರಿ ಈ ಅಮೌಂಟ್ ನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ.
ಹೌದು.
ಅಂಡ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದೆ, ನೀವು ಈ ತರ ಲಂಪ್ಸಮ್ ಕೊಟ್ರೆ ಆಗೋದಿಲ್ಲ,
ಹ್ಮ್
ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಪ್ರತಿ ಲ್ಯಾಂಡ್ಗೂ ಕೊಡಬೇಕು ಅಂತ.
ಹ್ಮ್
ಇನ್ ದಿ ಇಂಟ್ರೆಗ್ನಮ್ ತಾವು ತೋರಿಸಿದ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 13 ಬಂದಿತ್ತು.
ಹ್ಮ್
ದಿಸ್ ಇಸ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಕಾಮನ್ ಅವಾರ್ಡ್,
ಹ್ಮ್
ಬಟ್ ದಿಸ್ ಇಸ್ ನಾಟ್ an independent award. Be that as it may,
Hmm.
he has not drawn that amount, no compensation was paid. It is nobody's case that compensation was received.
was not claimed.
Not claimed, not paid,
Well, deposited in civil court, not
returned. No. What was
Returned.
deposited has been returned
claimed. All right.
and that has lapsed.
That is 3,24,000.
No, entire amount was deposited for the
ಅಲ್ಲ, page
the-
60 ಪರಿಹಾರ ವಿವರ.
ಪರಿಹಾರ ವಿವರ. ಅವರು
ಅದು
ಅದನ್ನ
ನಿಮ್ದು.
ಹೌದು, ಅದು ಕೋರ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಲ್ಲ.
ಹ?
ಎಂಟೈರ್ ಅಮೌಂಟ್ ನ ಒಟ್ಟಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ, ವೈಯಕ್ತಿಕ ಅವಾರ್ಡ್ ನಿರ್ಣಯ ನಿಮ್ದೇ ಅದು.
ಅವಾರ್ಡ್ ಬೇಸ್ಡ್ ಆನ್ ದಿ
ಕಾಮನ್ ಅವಾರ್ಡ್.
ಜನರಲ್ ಅವಾರ್ಡ್.
All right.
ಎವ್ರಿ ಒನ್ ವಾಸ್ ಈ ತರ ನಿಮಗ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳಿದ್ರು, ತಗೊಂಡೋಗಿಲ್ಲ. ಸೊ ದೇ ಡಿಪಾಸಿಟೆಡ್ ಇಟ್ under section 31.
No, these are all events that have happened earlier. You come into the picture in 2004, or the family comes into the picture in 2004.
No, with great respect, court heard them for over a day. That
I-
where is the land?
everybody over a day.
Allala, where is the land? Where is the village? I am answering that question.
All right, yes.
Where is the land? Sir, land is with me. My predecessor in title. It has never left my hand. It is still with me. I am the owner. I am the man in possession.
Then how did Muda form layout in that?
Yes, that is the $1 million
If
question.
you knew that you were in possession of the land and it was conspicuous,
Yes.
then how did you permit Muda to form a layout there?
My permission is needed.
No, ಆಗಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
You
ತಾವು
should have
ಕೇಳೋದ್ ನೋಡಿದ್ರೆ
objected
ನಾನು
to it.
ಪರ್ಮಿಷನ್ ತಗೊಂಡ್
Well,
ಮಾಡ್ತಾರೆ.
you have not objected to it any time.
No,
but
no,
this
with
is
great
land.
respect.
How are you
No,
forming a layout?
why should I object
Need not
when
object.
when the layout plan excluded this particular land?
But even then, land layout is formed in your land.
May ಇದು plans ಇದೆಯಲ್ಲ? ಇದೇನು? Yellow.
So anyway, the family comes into picture in 2004. Let's
Sir,
fast let's
kindly come
fast
to page
forward it to
52.
there.
Kindly come to page 52.
50?
52. ಇದು ಬೇರೆ ಫೈಲ್ ತಂದಿಲ್ವಾ? ಇದೆ ನೋಡಿ, ತೆಗಿರಿ. ಎಲ್ಲೋ ಫೈಲ್ ಒಂದಿದೆ. Page 52. Marked portion in page 52, the layout plan
Huh.
expressly declares that this is a denotified land.
Yeah. Yes.
So this was not included in the layout. It was left out. And I have the copy of the approved plan. I'll give it. There also, the survey numbers which are being subjected to the development are also specified. 464 is left out. So this was not part of the layout. So in these circumstances, the land has never left the
Hands of Devraj.
Devraj. It remained with him. He sold it in favor of my brother-in-law.
Then comes the
Yes.
family. into the
That
picture.
learned senior counsel has already covered. I will not trouble the court.
So, ಈಗ layout form, what is that?
The
scheme?
need of suspicion.
ಅಲ್ಲ,
Allah,
schemes.
the reason why I'm now the governor
Need
proceeds.
of suspicion.
The governor proceeds on the footing that possession is taken over. And my learned friend, Mr. K.G. Raghavan, eloquently argued the need of suspicion. ತಾವು ರಿಪೀಟೆಡ್ಲಿ ಕೇಳಿದ್ರಿ ಏನು ಇವ್ರ ರೋಲ್ ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಯಾರು ಉತ್ತರ ಕೊಡ್ಲಿಲ್ಲ. ದಿ ನೀಡ್ ಆಫ್ ಸಸ್ಪಿಷನ್ ಇರೋದ್ರಿಂದ ತಾವು ಅದಕ್ಕೂ ಹೇಳಿದ್ರಿ ಹೇರ್ ಸ್ಟ್ಯಾಕ್ ಅಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ಸೊ ದಿ ನೀಡ್ ಆಫ್ ವೇರ್ ಇಸ್ ಸಸ್ಪಿಷನ್ ಸರ್? ವೇರ್ ಇಸ್ ಪೊಸೆಷನ್? ಇಟ್ ಈಸ್ ವಿತ್ ಮೀ. A false statement is being made in the complaint that possession is with Muda. Governor records a perverse finding that the possession is Muda, and the entire case is built up on that foundation. The possession has never been handed over. The taking over of the possession is